Welcome to CPA Australia's Sound Business, podcasting for business and the accounting profession.
Welcome to today's podcast. My name is Mark Morris and I'm a Senior Tax Counsel with CPA Australia. Today it's my great pleasure to speak to Ian Raspin, who's a Director of B&R Partners, about Testamentary Trust. Welcome, Ian.
Thank you, Mark. Thanks for the invite.
Before we launch into the discussion on testamentary trusts, in a sense this is your specialist area, isn't it? Can you give us an idea what you do?
Yeah, absolutely, Mark. You're quite correct. We run a specialist practice right across Australia, actually, based here in Melbourne, that's specialising in deceased estates and testamentary trusts. We're working with a lot of trustee companies across Australia and supporting a lot of legal firms in this space as well, both on an advisory and a compliance base.
Okay, so you're the guru on testamentary trust, but you're too modest to say it. Okay. Well, Ian, if we're going to talk about deceased estates and testamentary trusts, would you mind providing us with a quick explanation of what those terms mean?
Yes, certainly, Mark. Look, it's perhaps easiest to describe a deceased estate as a trust that's established on the death of a person. It's essentially a vehicle that's used to hold the trust assets of the deceased that could be inherited by will during the administration of that deceased person's affairs. Once this is completed, and the corpus is then distributed in accordance with the will, or in case of no will, under the laws of intestacy. On the other hand, a testamentary trust is a trust that's established by either the terms of the will or in some cases even by statute.
Right.
It's essentially a trust that's established to hold the assets on behalf of the beneficiary after the administration of the deceased estates, basically without the beneficiary physically receiving legal title of those assets.
Yes.
For all intents and purposes, it's an efficient way of providing some sort of asset protection. It's interesting to note that testamentary trust could be discretionary in nature.
Okay, can you give us a couple of examples of what might be a testamentary trust?
Yeah, look, a couple of examples of testamentary trust would be by providing somebody the right to reside within your property during the terms of their life, or say providing them with an income stream for the terms of their life, and after which you decide that you'd like to vest the underlying assets in, say, a charity or perhaps within the grandchildren.
So a classic example of a testamentary trust, I guess, is where a widow might get a life interest being income from property, and then the property might be then transferred to grandchildren as capital beneficiaries.
Absolutely, a really good example.
All right, well, there's often confusion over the use of tax file numbers when it comes to the administration of an estate. Can you explain what tax file numbers are actually required?
Yeah, Mark, you're actually right. And look, we certainly see a couple of different practices being used across the marketplace. Basically, there are a minimum of 2 tax file numbers that could be requested or required during the process of the management of an estate.
Right.
First one really comes down to that tax file number we've already got, and so when the deceased dies, using their current tax file number to lodge their final tax return, which is really from the 1st of July up to their date of death, and this is otherwise known as a date of death tax return.
Yep.
Second tax file number really comes into existence through the management of that deceased estate, which is treated as an entirely separate taxpayer. And if there's provision for a testamentary trust in accordance with the will to be established over and above that, then this trust will also require a separate tax file number, again as it's seen as a totally separate legal entity.
So to do it properly, you really need at least 2 file numbers where you've got a deceased estate and up to 3 if you've got a testamentary trust.
Absolutely correct.
Is it possible that an estate could actually allow for more than one testamentary trust?
Yeah, good question. A will can certainly establish more than one testamentary trust, and therefore it is possible for multiple TFNs would be required for such trusts.
So if you had, for example, 2 kids, you might have 2 testamentary trusts?
Absolutely, absolutely. Or in fact, the 2 kids could be involved in one testamentary trust, depending on the terms of the will. And
so reading the terms of the will is paramount, isn't it? And if you're in trouble,
absolutely.
Go and see an estate lawyer.
Spot on, Mark, spot on.
Okay. Well, whilst we're on the subject of tax file numbers, we've both been involved in many discussions on the TFN withholding rules that the federal government have introduced way back in July 2010. Do you mind outlining what impact these TFN withholding rules have had on deceased estates and testamentary trusts?
Yeah, look, basically as you point out, the federal government did introduce legislation that requires trustees to collect and report TFNs of beneficiaries of closely held trusts to the ATO before they physically distribute income to a beneficiary, or before that beneficiary even becomes presently entitled to that income. Broadly, this is a one-off obligation which will be met when the beneficiary provides his or her TFN number to the trustee. But again, that's important that that's actually done before the trust distribution is made or before they become presently entitled.
So obviously it's an important thing to get the tax file number and before the distribution or present entitlement's made. But once you've got that TFN on record, then it's a once-off.
Absolutely, Mark.
Now, turning to testamentary trust, how do the TFN rules work in that context?
Yeah, look, as part of this regime, the trustee of a testamentary trust is also required to, go and collect the tax file numbers from beneficiaries. However, a deceased estate is excluded from this reporting regime for a period up to 5 years from the date of death of deceased. So it's actually quite important to emphasise that there is a difference between the deceased estate and the testamentary trust, because that 5-year exemption doesn't apply to testamentary trusts.
But does apply to deceased estate.
No, that's absolutely correct. Look, where the beneficiary doesn't actually go and provide their TFN, then unfortunately the trustee is required to withhold PAYG, effectively 46.5% of the distribution that would have been made to that beneficiary, or that beneficiary was presently entitled to, and make that payment to the ATO. An annual payment summary is then made out of that, which is provided to the beneficiary, much like your PAYG summary for your wages. And this amount is a credit that they can obviously go back and lodge and claim on their income tax return. Quite a few compliance hassles through there when a TFN's not provided, and you see across the country that trustee companies and executors and certainly trustees of testamentary trusts are really somewhat burdened by this process.
Okay. And some beneficiaries are excluded from the TFN reporting system, aren't they?
Yeah, absolutely right, Mark. Those beneficiaries under, say, legal disability, such as minors, non-resident, and exempt entities such as charities.
Nonetheless, that sounds like quite a bit of work. You've previously told me there's cases of widows who have been very reluctant to comply with this request to provide a TFN. Why do you think that is, and why is it such a problem?
Yeah, look, I think you'll find a lot of the older generation have never really had a need for a tax file number. You see cases with a widow that's been the stay-at-home mum from day one and never worked. So basically, they've
never worked outside the home, eh?
Correctly pointed out, Mark. Very nice. Basically, she's never really had to apply for a TFN, and effectively, even now that she's receiving the age pension. Yeah. So now a testamentary trust is established, and she's finding that the trustee's asking for a tax file number, and she's never had to apply for one of these, and she's probably in her 80s and 90s and going, well, why do I need this? This is too complex.
And intrusive, perhaps.
Definitely intrusive. In fact, a lot of these people are somewhat sceptical about what the motivation of maybe the government or the trustee company is in that particular case.
So basically, if a trustee cannot obtain the tax file number, and you've got a testamentary trust which aren't exempted, you're going to have to withhold the tax at 46.5%, aren't you?
Absolutely right, Mark. And to be honest, I've actually seen cases where beneficiaries would rather have that tax withheld from that payment and claim it back in their tax return later on, as opposed to actually going out and giving people their tax file numbers.
Which is an important point, isn't it? So this is a timing difference in essence.
Purely a timing difference.
Yeah, but nonetheless you want to get it right. And of course, if you're the trustee and you don't withhold tax when you should, you'll be separately liable for penalties, won't you?
Absolutely, in your own right, which is a pretty nasty sting.
Well, turning to something else, we often used to talk about obtaining a tax clearance in terms of deceased estates and testamentary trust. I was interested to learn recently that the ATO no longer provide a tax clearance letter. Is that right? What are some of the ramifications?
Yeah, look, Mark, you're 100% right there. You used to be able to write to the ATO and ask the Commissioner for a tax clearance letter, and that essentially provided some sort of certainty and, protection for the executor. The Commissioner has ceased that practice some time ago, and it's really now a really unclear position about the liability of the executor, who may in fact distribute trust assets and tax debt subsequently comes out. A real quandrum.
Okay. As a corollary, does that mean the executor could be liable for tax after the estate's been administered?
Yes, that's potentially right. It's an area with a high degree of uncertainty, and in my mind probably needs clearing up. The executor of the estate, for all intents and purposes, stands in the shoes of the deceased, and therefore you're fully responsible for tax obligations. You should therefore really make sure that all the debts of the deceased are addressed prior to transferring those assets, or, as you rightly point out, potentially take the risk of having that debt yourself.
Given that risk, what suggestions would you have for an executor to minimise that uncertainty or risk?
I guess caution is the word that really comes to mind there, Mark. And that is to take as many steps as you can, like, going on record with the ATO. They record all their telephone conversations, so at least there's a record that you've made some inquiry.
Yes.
Going back and ensuring all of those outstanding tax returns are actually lodged. Waiting for the ATO to issue that notice of assessment. Physically pay that tax debt prior to distributing the money.
Yep.
Various states have got legislation around advertising for debtors or creditors to come forward, so certainly follow those things. And I guess the final one that I'd suggest there is that you could turn around to the beneficiaries and seek indemnity from them, that should a subsequent tax claim come up, that they'd indemnify you. Generally, you find beneficiaries are pretty keen to get their inheritance.
Yep.
But I guess the downside of that is that indemnity is only as good as them still having the money. If they go and spend the money or push it somewhere else where you can't access it, then again you're left in a really liable position potentially.
Okay. Well, it's obviously quite an important issue as to whether you take on an executor role, isn't it? And perhaps you should get professional counsel before you do.
Yeah, look, Mark, before I started really working in this area, I worked in business services, and certainly through that role I would accept, for some of my major clients, the appointment of an executorial role in their estate, because it would be seen as an honourable thing. They've asked you to do that. But having now played in this field for a number of years, I can see that, quite frankly, the liability and the work that goes into this, I refuse taking executorial roles nowadays. Leave it to the experts.
That's real food for thought. Well, turning to capital gains tax for a moment, in the context of deceased estates, can you lead us through the purpose and functions of CGT Event K3? Because that's quite an important CGT rule, isn't it, which I suspect is not always well understood.
I think you're 100% right, Mark, and again, talking about the liability of, I guess, executors, this is one that could come back and bite you. But look, basically CGT Event K3 comes into existence when the assets of the deceased Australian taxpayer are transferred to either a non-resident or a tax-advantaged entity, which is effectively a charity without the DGR, the deductible gift recipient status, which is like the Red Cross.
Yep.
A capital gain effectively arises if the market value of that asset on the date of the deceased person passing away is more than its actual cost base.
Yep.
Look, in the case of foreign residents, I guess I've really always viewed this as the case where the Commissioner is basically ensuring he obtains the tax on that capital growth before the asset leaves Australian shores, and therefore just getting his opportunity then. And it's really important to say that.
So because once it's non-taxable Australian property, it's out of his reach, isn't it?
Absolutely
when you're
correct.
a non-resident.
Absolutely correct, Mark. Yeah.
Okay. I understand there's an exemption for taxable Australian property under CGT Event K3 where the assets transferred by the deceased to a foreign resident. Is that correct?
Yeah, Mark, absolutely correct. Basically, the CGT event in that case is deferred if the asset's being transferred by the deceased falls into the definition, as you say, taxable Australian property.
So what's taxable Australian property then?
Yeah, look, broadly, this includes any interest in Australian real property, such as the lease of a land, an interest in minerals, quarrying or petroleum situated here in Australia. Also includes shares and interest in a company or trust.
Yep.
Where the deceased or its associates held more than 10% of the interest of that company or trust. But it's important to say that the underlying assets of that particular entity need to be the majority of taxable Australian property.
Based on a market valuation. So if you like, the more than 50% of the underlying assets has to be, from a market value basis, comprise taxable Australian.
Absolutely correct, Mark. Yeah, absolutely correct.
So important that you look at the shares in a company. So if it's shares in an insurance company that doesn't own land, it's okay. If it's shares in a mining company which has mainly got land, then you've got an issue, haven't you?
Yeah, no, 100%, Mark.
So who physically pays the tax when CGT Event K3 happens?
Yeah, look, Mark, that's actually a really topical point. When that CGT Event K3 actually occurs, you need to actually go back and include that within a deceased
date of death return.
Absolutely, Mark. Because that K3 event's actually deemed to have occurred just prior to the deceased being passing away.
Yep.
So basically, it often means that date of death return actually needs to be amended after, once that K3 event actually happens. It becomes really problematic, for example, when assets, say, sit in a testamentary trust for a number of years. We were talking about those earlier with life interests, etc.
Yes.
And then they vest and remain a beneficiary as a charity or something. So really,
you've got a problem, haven't you? Because if it's supposed to be in the date of death return, this happens 5 years down the pike.
Absolutely,
you're
right.
out of time to amend the deceased date of death return.
That's correct. That's correct.
So where do you think we sit with this? Because clearly that could happen. I recall the federal government proposed in the 2012 federal budget to amend the legislation to ensure that K3 was actually captured and taxed against the transferring taxpayer, which of course could be, happen years after the date of death return.
Yeah, look, I think that was a really good initiative of the government, but unfortunately it was one of those many tax initiatives that was actually scrapped just prior to Christmas.
Yep.
And quite hopefully, this will be addressed at some stage going forward because, again, given the 2 or 4 year amendment period, there's CGT events here that could go untaxed, and some of those can be very significant.
Yep. Well, maybe they'll get a pragmatic approach. Talking about pragmatic approaches, there is another estate taxation amendment the federal government did not proceed with, is that practice statement PSLA 2003/12 will not be codified, contrary to what was announced in the 2013 federal budget. How important is that?
Yeah, look, Mark, I would have thought that that would have provided some absolute certainty going forward. So really, I feel it was probably a really missed opportunity.
Yep.
Look, a bit of background there, as you're aware, Division 128 currently provides an exemption for CGT of assets that pass from the deceased legal personal representative or executor to the beneficiary.
Right, so when a transfer to an executor or beneficiary, you don't trigger CGT.
That's
under
correct.
Division 28.
Yeah, that's correct. It gives you an exemption through there, but with testamentary trust, though, it's not actually explicitly covered by that provision.
Under Division 128.
That's correct, and so we're really relying on that practice statement, 2003/12, which indicates that the Commissioner is going to treat that transfer from a testamentary trust the same as a transfer from a deceased estate.
So it's an administrative concession, but he's basically saying in administering Division 128, whether it's a transfer from a legal personal representative or a trustee of a testamentary trust to a beneficiary, in either case that won't trigger capital gains tax. But there's no real legal foundation.
Absolutely correct, Mark. And as we both know, the problem with practice statements is that the Commissioner can withdraw them at any particular time. To actually have codified that in legislation, I think, would have provided a very solid foundation for the industry as a whole.
That said, that practice statement, as I recall, basically stressed that if they took a contrary view and taxed it, would cause mayhem in the trustee arena, estate trust arena. So hopefully common sense will prevail on that one.
Yeah.
But nonetheless, I agree with you, it would have been good to codify it. Are there any other tips around capital gains tax that you think should be considered?
Yeah, look, I think the thing that we see missed a little bit are collectibles and personal use assets. Very important to just note that they do potentially have CGT events.
Yep.
Yeah, the other one is that we get a lot of questions surrounding capital losses. It's important to remember that those losses can't actually be transferred from, say, the date of death return, the deceased estate, and if one is established to a testamentary trust. These are effectively quarantined and lost if they're not used, and I find that a number of professionals in the marketplace actually are under the misunderstanding that those losses can actually be transferred, which is not the case.
Yep. So they expire, don't they?
They expire,
in essence.
Yeah. Ideally, I guess, if you knew you were going to die, you might actually, sell some assets if you had some capital losses before your death. But, we don't really often have that opportunity to do that sort of structuring or planning.
No, well, if you do, you've got an interesting client base. An unfortunate one.
And I guess the other one where we see a lot of money wasted from estates is the CGT records. It's really important to emphasise that you must collate those records, keep those going with your clients so that when somebody does pass away, you're not spending thousands of dollars and actually rebuilding those through share portfolios and things.
Finally, and you mentioned something previously to me about minor beneficiaries and that they may be missing out on tax refunds they're otherwise eligible to receive. Can you explain what that omission might be?
Yeah, look, pretty straightforward actually, Mark, but as you correctly point out, it can actually be very easily overlooked. Basically, as I think most people would know, minor beneficiaries of testamentary trust enjoy the same marginal rates as adults, and that's one of the real attractions of testamentary trusts. When these minors are made presently entitled to that income, the trustee is actually assessed on behalf of that minor and pays that tax. But it's really interesting to point out that the trustee is not actually eligible to receive back any unused franking credits that goes along with that distribution. So it's effectively possible for the miner to take a beneficiary statement, a letter that goes out to the beneficiary to say what their income was and that it's already been taxed in the hands of the trustee. It's possible for that miner to take that beneficiary statement and lodge their own income tax return and effectively, depending on their other income, obtain back the unused franking credits.
Okay, well, that's an interesting quirk that people should bear in mind, isn't it?
And seriously, Mark, it can amount into thousands of dollars over a number of years.
Okay, terrific. Well, Ian, thank you for leading us through the terrain of testamentary trusts. I think I got a lot out of it. And obviously, as we go through the consultative process and some of those unfinished business items are addressed by the government or the ATO, we'll be keen to talk to you further about them. Thank you.
Thanks, Mark, for having us.